jury felt enough sympathy, mercy for you that they decided that you deserved the death penalty.
He confessed. Yeah, I shot her mom.
And there is the other mother with the gun.
In October 2023, Albuquerque mother Rayana Ruiz was at home when her daughter said she saw a man in their backyard. Concerned, Ruiz got into an SUV with her daughter and another minor, following the man through their northeast neighborhood until he reached an apartment complex. Surveillance video captured the group arriving moments before a confrontation at the apartment door, during which shots were fired.
You'll see Mr. Roybal walking up the stairs there at that point. The minors. And there is the other minor with the gun.
Santiago Roybal, a young man described by his family as kind and conflict-avoiding, tragically lost his life, and another person was hurt.
Time that I hear him say, "Grandma," and he's not there.
Nearly 2 years later, Ruiz stood in court for sentencing. Roybal's grandmother spoke about the pain her family continues to endure and the emptiness left by his absence.
He would just never, ever fight with anybody. He always tried to avoid things and trouble. I ask that she gets everything that's coming to her.
Judge Cindy Leos sentenced Ruiz to 20 years in prison for second-degree murder and related charges. Her daughter, Dylann Roof, is scheduled to face trial for her role in the case in September 2025, while the victim's family continues to seek closure. In June 2019, 26-year-old Sacramento police officer Tara O'Sullivan responded to a domestic disturbance call as part of her patrol duties. While assisting at the scene, she was caught in an ambush by Adol Ramos, turning a routine response into a tragic event that shook the department and the community. Fellow officers and first responders were unable to reach her in time, and the young officer was later pronounced dead. Her dedication and service were widely honored in the days that followed, as Sacramento mourned the loss of a promising officer. After years of court proceedings, Ramos was convicted of murder with special circumstances and formally sentenced to death in June 2025, following a jury's recommendation earlier in March. Although California currently has a moratorium on executions, prosecutors pursued the case as a matter of accountability for the calculated attack. Sacramento officials and police leadership said the sentence brings a measure of justice, and they emphasized that Tara O'Sullivan's service and sacrifice will never be forgotten. In June 2025, a quiet neighborhood in Preble County, Ohio, was shaken by a tragic misunderstanding. Investigators say 59-year-old Kenneth Brabant saw a motorcycle pass his home late at night and believed the rider was connected to a personal dispute involving his daughter. Acting on that mistaken belief, he confronted the motorcycle and struck its passenger, 41-year-old Leah Hoare, outside a home on Upper Summers Road. She was later pronounced dead, leaving family and friends mourning the loss of a devoted single mother remembered for her strength during a long battle with cancer. Brabant was taken into custody the following day, and detectives testified that he became emotional when he realized he had targeted the wrong person.
He seen the motorcycle coming and he swung. So I asked him what he swung. He said, "That's the bad part." I said, "What was it?" He said, "It was a machete."
A judge found probable cause to move the case to common pleas court, and Brabant now faces charges including murder and felonious assault. He remains in custody on a $1 million bond, awaiting further hearings as the community seeks justice for the sudden and heartbreaking loss. On the morning of July 1st, 2025, 22-year-old Blake Herring, who identifies as female, was seen on surveillance footage inside a Southfield Meijer store, browsing tools before selecting a hatchet.
Captured in Meijer's, purchasing a hatchet. Not only purchasing a hatchet, practice swinging a hatchet.
Authorities say she spent time near a nearby PNC bank on Northwestern Highway, appearing to observe the area. Around midday, Herring entered the bank and confronted a staff member, resulting in an injury.
Then from there, go to the bank, casing out the bank for about 30 minutes, and then walk into that bank, immediately assault our victim, and then demand money. She's at home recovering as she stayed in the hospital for several days.
After demanding cash, she left with approximately $2,000 and returned to her apartment in Dearborn Heights.
There's no suggestion of mental illness. What I believe is someone who decided to rob a bank.
Thanks to clear video evidence and swift coordination between Southfield Police and the FBI, investigators located and arrested Herring within 24 hours.
South Police 911, how can we help you?
I think we just got robbed.
A search of her apartment and vehicle reportedly recovered a portion of the stolen cash. Prosecutors have charged her with bank robbery and assault with intent to murder, both carrying potential life sentences. She's currently being held on a $2 million bond as the investigation continues and the injured bank employee recovers at home. In November 2022, 33-year-old Mario Redmond was found dead inside a Milwaukee home near 46th and Locust. Surveillance footage and other evidence led investigators to charge Lance Wyndham, then 31, with first-degree intentional homicide as a party to the crime.
This is a 2022 homicide. The victim is shot in the face. Although everyone says they didn't see the shooting, it's a very orchestrated situation and has come together now.
As the case moved toward trial, prosecutors encountered a setback in May 2025 when a key witness failed to appear. They requested that the case be dismissed without prejudice, allowing it to be refiled later. In July 2025, prosecutors officially refiled the charges, stating that new evidence had come to light, though its specifics have not been made public.
The state wants to use that in a trial.
Wyndham is also facing a separate case involving the 2023 death of Michael Shraven, a local mechanic. According to court documents, Wyndham allegedly made a concerning comment during a recorded jail call just before the incident occurred. Prosecutors believe that unresolved tensions between the two played a role. With both cases moving forward, Wyndham remains in custody on $250,000 bond in each. The court is now preparing for the next phase of proceedings, as both cases are expected to be heard later this year. In the summer of 2022, 24-year-old Alanya Lenoir vanished after visiting an apartment complex in Midtown Atlanta. Surveillance footage showed her entering with friends, but never leaving. Investigators later concluded that she died inside the apartment and her body was secretly removed. Police linked 3 men to her disappearance: Deontay Reynolds, Nicholas Hendrickson, and Stephen O'Boy. Reynolds was arrested first, facing murder and evidence tampering charges. Hendrickson was taken into custody months later for allegedly helping to dispose of her body. The third suspect, O'Boy, fled for months before his dramatic capture in 2024, when authorities caught him after a jet ski chase on Lake Allatoona. For nearly 3 years, all 3 men were held without bond as Lenoir's mother, Jeanette Jackson, pleaded for justice. That changed in mid-2025 when a judge granted Hendrickson a $20,000 bond after he had spent more than 950 days behind bars, citing that his time served already exceeded the typical sentencing for his charges.
What's your frustration level at that Nicholas Hendrickson got a $20,000 bond?
My level is super high. That just feels like an additional slap in the face.
I was devastated and I felt betrayed because they told me this would not happen.
Reports indicated the bond allowed him to attend his father's funeral, a decision Jackson described as a slap in the face since she still cannot bury her daughter.
Even if it was one of the reasons, it's very insensitive of Fulton County to put that on paper. I feel extremely disappointed in how Fulton County has chosen to handle this.
The other 2 suspects remain in custody, no trial date has been set, and Lenoir's body has yet to be found, leaving her family in a painful wait for closure. In the quiet town of Belmont, Ohio, tragedy struck in September 2021 when the home of Tom and Angela Strushin went up in flames. Fire crews quickly made a chilling discovery: the couple had been murdered before the fire was set. For years, detectives chased leads across multiple states, slowly unraveling a deadly plot. Their investigation pointed to Andrew Isaac Griffin, a former business associate who was arrested in Hawaii in 2025 after a dramatic multi-state manhunt. He now faces aggravated murder charges with a capital trial set for March 2026. But the hunt for justice faced an unexpected roadblock. Investigators traveled to Oklahoma to question Dalton Ray, a man they believed had crucial information. Instead, he lied twice, wasting valuable time and delaying answers for the grieving families. When confronted with evidence, he fled, forcing officers to track him down.
Resources that could have been used to further that investigation had to be used to prove that you lied in furtherance of their investigation. You wasted time, you wasted resources, and you delayed victims' families getting answers.
The officers at the time didn't know any different. Shortly after that, they learned that Mr. Ray was outright lying to them. They then returned to Oklahoma again about a month later to interview him. He again continued to lie, and then the officers confronted him with the information they had uncovered showing his lie. And at that point, he terminated the interview and actually fled from the officers.
In June 2025, Ray was convicted of obstructing justice and sentenced to 2.5 years in prison. Meanwhile, Griffin remains behind bars, and the Strushin family still waits for the day a jury will decide the fate of the man accused of ending 2 lives in cold blood. In the early morning of September 30th, 2024, a tragic crash shook Warren, Michigan. Former police officer James Burke was driving his patrol SUV down Schoenherr Road at an estimated 117 miles per hour, nearly 3 times the 40-mile-per-hour speed limit without lights or sirens activated. At the same moment, 34-year-old Cedric Hayden Jr. and his best friend, 33-year-old DeJuan Pettis, attempted to make a left turn in their Dodge Durango. The collision both men instantly. Investigators concluded that nothing the victims could have done would have avoided the impact.
There was nothing that these gentlemen could have done to avoid this crash.
Months later, Burke was charged with 2 counts of manslaughter and related misdemeanors for causing the deadly crash.
The video is very hard for the family to watch. It's hard for anybody to watch. And really, the video is the best evidence.
In court, prosecutors played dash cam and surveillance footage of his speeding SUV, while a crash reconstructionist testified to the extreme force of the impact.
What does it indicate the speed is at this point in time?
117 miles an hour.
So these actually don't demonstrate the distance between the Explorer, if he would have been doing those times, and the point of impact.
Correct.
Attention to detail is important in these cases, isn't it, Deputy?
Yes, sir.
The defense argued that the victim's left turn might have been a civil infraction, but the central claim remained that Burke's reckless speed and failure to use emergency equipment caused the deaths. As the preliminary hearing continues, Burke remains free on bond, and the victims' families continue to wait for full accountability. In June 2025, 26-year-old Ryan Godby was reported missing in Canton, Ohio, after last being seen at a local bar. When investigators searched his apartment, they found evidence that raised serious concerns about his safety and shifted the case to a homicide investigation. A few days later, police arrested 33-year-old Daniel Matte, a man closely connected to Godby. As the investigation continued, his charges grew to include murder, assault, and domestic violence, and authorities alleged that he tried to mislead them about Ryan's disappearance. By early July, the case moved into court. During a bond hearing, the judge noted new allegations that Maddie attempted to escape from jail and caused property damage, raising concerns that he might not appear for future proceedings.
Ready, Your Honor?
Yep.
Daniel Matte, 2025 CRA 2676, felonious assault, extortion, and domestic violence. 2025 CRA 2680, attempt to commit escape and vandalism. Your Honor, when appropriate, the state would like to be heard on bond.
Mr. Matte, your attorney, Mr. Kowalczyk, is here. I'm going to let him speak on your behalf. You've got some papers there. Do you understand those charges?
Yes, sir.
Okay. Mr. Kowalczyk?
Thank you, Your Honor. We acknowledge receiving copies of the complaint. Waive formal reading. Ask for this matter to be set for a status conference.
I don't see much sense in setting it for a status since we don't have much time. I'm going to set it for a prelim.
I'm fine with that.
Friday the 11th.
That works.
Okay, at 10:30. And state, you want to be heard on bond?
Yes, Your Honor. On Friday, Judge Falvey set a $1 million bond on the murder charge. We would just ask that you keep that bond as set.
Mr. Kowalczyk, do you have anything to say?
Not at this time.
Okay. Actually, court's become aware that since he was served with these warrants, he's also been charged with an attempt to escape and a vandalism while at the Stark County Jail, which indicates to me a willingness not to appear in court. So I'm going to up that bond to $1.5 million.
Thank you, Your Honor.
And we will set the prelim for this Friday, the 11th at 10:30 a.m.
Okay.
Thank you.
Thank you.
His bond, originally set at $1 million, was increased to $1.5 million, and he remains in custody as of now. Ryan Godbee has not yet been located, and the investigation continues while his family waits for answers and justice. In the summer of 2025, the small community of St. Gabriel, Louisiana, was shaken by the death of Police Captain Devin Bout, 34. Investigators revealed that Bout had been in a complicated relationship with 25-year-old Warren Mitchell III, who had a history of robbery and drug offenses.
Drugs, robbery, even some indecent behavior with back when he was a juvenile.
Authorities say Bout had been providing Mitchell with drugs to use and sell, and their relationship had become increasingly strained. Mitchell allegedly felt trapped, and the situation had drawn the attention of the Iberville Parish Sheriff's Office, which had even referred the matter to the State Attorney General for review just days before the incident.
Seems to be that Booty lost his direction through the relationship with this man. It clouded his judgment. He thought that he was trapped in this relationship and this was the only way out. He had attempted a couple times prior to get out of this relationship, and he couldn't seem to get away.
Meaning what exactly?
A few weeks ago, he did a robbery at a store, knowing that he would be arrested and brought to jail, and that in fact happened. He posted a $27,000 bond, and Captain Booty went to the store and tried to repay the money and asked that they would come forward to drop charge. He used some coercion and to keep pressure on him that I went and paid the money back. I got you out of the mill place. I did this. Just some control tactics that he used to kind of control him.
On July 6, 2025, Bout was found in the home he shared with Mitchell, leading to an immediate investigation and Mitchell's arrest.
I was notified by the sailor, sent an officer out. I came out and checked myself, and I ended up finding him succumb to his injuries. Hopefully I'll never have to witness something like that again.
Detectives later confirmed the presence of drugs in the home and said Mitchell expressed regret, claiming the relationship had become unbearable. He was booked on second-degree murder charges and held on $500,000 bond, while the community mourned the loss of a respected officer whose career and personal life had taken a tragic turn. In April 2023, family and colleagues grew worried when Detroit neurosurgeon Dr. Devin Hoover stopped answering calls and failed to show up for a planned visit with his mother. A welfare check at his Boston Edison home led police to a disturbing discovery. He had been killed and hidden inside the house. His white Range Rover was also found parked nearby, with clear signs that something had gone wrong. For months, investigators searched for answers. They eventually focused on Desmond Burks, a man who had been in close contact with Dr. Hoover. Evidence showed the two shared a personal relationship, supported by thousands of exchanged messages. Surveillance cameras later placed Burks with Hoover's vehicle, and financial records revealed nearly $21,000 in unauthorized transactions linked to Burks after Hoover's death. As police pieced the case together, witnesses testified that they had helped Burks get rid of items belonging to Dr. Hoover, including clothing and personal effects. Some admitted they knew about fraudulent activity carried out in the days after the doctor went missing. These accounts strengthened the prosecution's case. By August 2024, Burks was formally charged with first-degree premeditated murder, felony murder, larceny, weapons offenses, and computer crimes. He also faced sentencing as a habitual offender because of his criminal history.
This is the case of the people of the state of Michigan versus Desmond Burks, charged with count 1, homicide, murder in the second degree, with an habitual offender fourth offense notice. I'm also calling case number 240-572-4801. In that case, that is the people of the state of Michigan versus Desmond Burks, charged with count 1, homicide, murder in the first degree, premeditated, count 2, homicide, felony murder, count 3, larceny of $20,000 or more, count 4, computers using to commit a crime, count 5, weapons, firearms, possession by a felon, count 6, weapons, felony, firearms, second offense, count 7, weapons, felony, firearms, second offense, count 8, weapons, felony, firearm, second offense, with an habitual offender fourth offense notice. This is the date and time set for competency hearing regarding both of these matters. Will the parties please identify themselves for the record?
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan, P number 39570, and I will be also accompanied by Mike Glenn.
And good morning, Your Honor. Gabby Silver appearing on behalf of Jasmine Burks, who I see is appearing via Zoom video from the Wayne County Jail. For purposes of this hearing, we have no objection to appearing via Zoom.
All right.
Mr. Burks, can you tell the judge your name, please?
Mr. Burks.
As it relates to this matter, Judge, we do have a forensic center report from the CRE findings Mr. Burks competent. We had an independent evaluation done as well. That evaluation also found Mr. Burks competent. So we are prepared to schedule exam dates.
All right, so obviously the parties are stipulating to the finding that Mr. Burks has been found to be competent to stand trial. I'm just going to ask for the record. I'm assuming both of the parties are going to stipulate to that finding.
Yes, Your Honor. On behalf of the defense, as to both matters, we stipulate to those findings.
All right.
Yes, the people stipulate us well.
All right, so with that, Attorney Silver and Attorney Lindsay, in terms of preference, are you trying to do the exam for the case ending at 801 first?
I don't have the case numbers in front of us, Judge. Is that the charge of murder too?
Yes. 801 is with the homicide second degree.
Okay. So I think that case, as I understand the proofs in that case, should take about a half a day to do the preliminary exam.
Okay.
So that would be much easier to schedule.
Later this afternoon, but is there anything else you two want to raise?
Yes, sir. I believe that basically just for the record, we have to put the finding, even though we said he was competent on the record, we have to put the finding on the record that he was in fact understands the proceedings against him, and basically just put the last paragraph of the findings of Dr. Rodriguez, where she says, in sum, I can find no mental condition impairing Mr. Burks' capacity to proceed with this case at this time. Based on this and the statutory presumption of competence, it is my opinion that Mr. Burks is competent to stand trial. And as it relates to the opinion of Dr. Abramsky found in regards to the issue of competence, Desmond Burks has demonstrated adequate knowledge of the criminal process and the role of participants. Furthermore, I find he is able to participate in the legal proceedings in a meaningful way. His ability to understand, acquire information, and process kinds of intact. In summary, Mr. Burks appears to meet the threshold of competency as set forth by the current standards. So with those findings being put on the record, I believe that satisfies the issue.
All right, and I guess just to add a little bit.
Satisfied, but that's fine.
All right. I was just going to add, of course, Attorney Lindsay, the first report that you read from was from I believe Dr. Karina Rodriguez from the Center for Forensic Psychiatry. That was the initial report from December 3rd of 2024. The subsequent report that you just read was from Dr. Atara Bramsky from February 20th of 2025. Am I correct?
Correct.
All right. All right. Anything further?
Nothing. Will be in touch with your clerk this afternoon, and hopefully we'll get some dates pretty soon.
All right. Thank you both.
Thank you.
In early 2025, mental health evaluations confirmed that he was competent to stand trial, with experts concluding he understood the legal process and could assist in his defense. By June 2025, a 4-day preliminary hearing laid out the case in court. After hearing testimony and reviewing the evidence, the judge ruled there was enough probable cause to send Burks to trial. In July, the court officially scheduled that trial to begin on January 5th, 2026. In late November 2017, Mariah Woods was put to bed at her family's home in Onslow County, North Carolina. The next morning, she was gone. Her mother's boyfriend, Earl Kimry, placed a 911 call telling dispatchers that Mariah had vanished overnight and that her pink footy pajamas had been found lying next to her bed. He insisted he had searched the house and yard, but could not find her.
Yes, ma'am. I'm at 2405 Dustin Gavin Road, Lot 7.
Could you repeat the address for verification, sir?
2405 Lot 7 Dustin Gavin Road.
And tell me exactly what happened.
She is nowhere to be found. We would look everywhere in our house, in our yard, in our little girl. She's missing.
Okay, how old is she, sir?
She's 4 years old.
Okay, so let me get some information from you, okay?
Yes, ma'am.
All right, so when was the last time you seen her?
We went to bed last night. Everyone went to bed at the same time.
And what time is that, sir?
Maybe 8 o'clock, 8:30.
All right, let's get this information in the system. And you looked in the bedroom, under the bed, and everywhere, sir? Not able to?
Everyone's closets, under, and everywhere. We went to the house 2 or 3 times.
Okay.
In the yard. It's not like her to go outside at all. But not in the middle of the night or in the morning by herself.
Yes, sir. Now, does she have a physical, medical, or mental condition we need to be aware of?
She has muscular dystrophy. She's palsy. She goes down a lot. That's it. But otherwise, she's perfectly able.
Okay. All right, so I need to get a description. What race is she?
She's white, blonde hair, about 3 feet tall.
Do you know how much she weighs?
About 30 pounds.
Okay, does she have any characteristics on her face, like scars or birthmarks, anything?
Blue eyes. She had pajamas.
Okay. And what kind of PJs did you put her in, sir? What color? Do you remember?
They were pink.
Okay, and her name?
Her name is Mariah.
Mariah?
Woods.
Last name Woods?
The disappearance quickly drew national attention. Law enforcement, the FBI, and volunteers launched a massive search, scouring woods, creeks, and abandoned areas across the region. The community gathered in prayer vigils, hoping Mariah would be found safe, but nearly a week later, dive teams discovered her body in Holly Shelter Creek, around 30 miles from her home. An autopsy revealed she had died from chloroform poisoning, a deliberate act that changed the case from a search to a criminal investigation. Kimry was arrested in January 2018 and charged with first-degree murder, felony child abuse, obstruction of justice, concealment of death, burglary, and possession of stolen property.
Thank you, Your Honor. The first thing I'd like to do is the motion for Rule 24 hearing. Judge, for the record, the defendant, first of all, for the record, the defendant is present. He's also represented by counsel today. Judge, as to this particular case, the defendant was indicted on February the 13th of 2018. There were 4 separate indictments handed down at that time. Judge, those file numbers were 18 CRS 50503, 18 CRS 50504, 17 CRS 57545, and 17 CRS 57544. Judge, at this time, the state would like to proceed with the Rule 24. For the record, Judge, I filed a motion for Rule 24 here back on February the 14th of 2018. At the same time, on the same date, I filed a notice of arraignment. And then, Judge, on February the 15th, 2018, I filed a notice of intent to seek the death penalty pursuant to 15A-2004. Those are all filed with the court. Judge, at this time, we would like to proceed with the Rule 24 pretrial conference. Then after that, proceed with the arraignment. Okay, very well. Judge, as to the Rule 24 pretrial conference, the state would contend that the state will be seeking the death penalty on this particular case. The state would contend there's at least one aggravated circumstance pursuant to 15A-2000. Therefore, it would make this case a capital case. And Judge, I'm going to go through the arraignments. The judge in 18 CRS 50503, the defendant was indicted for the offense of first-degree murder. That was on February the 13th, 2018.
Just for the record, my name is Walter Chairman versus God knows. I'm appointed here by reason of capital defendant. The process has been started and second counsel is in the courtroom and will immediately step into her role, Ms. Brooke Magnum of the Assistant Capital Defender as second counsel in this case. If please court, Mr. Lee has furnished me with a copy of the indictments. I reviewed those with my client as late as Saturday. Two, please, I have received a motion for Rule 24 in the notice of the state of North Carolina from Chapter 15A 2000 and the other statutes will be seeking the death penalty in this case. And there is the appropriate allegation according to Mr. Lee's evaluation of the case, there is sufficient evidence to present a capital aggravating factor to the jury.
Prosecutors announced their intention to seek the death penalty, citing the seriousness of the crime and its aggravating circumstances. In court, Kimry pleaded not guilty, and the case stretched on for years, slowed by legal maneuvering and pandemic-related delays. Then, in December 2022, he changed his plea. Under an agreement with prosecutors, Kimry admitted guilt to first-degree murder and felony child abuse, removing the possibility of a death sentence, but ensuring he would never leave prison. During the sentencing, prosecutors revealed that Kimry had admitted to fellow inmates that he used chloroform to silence Mariah. The judge sentenced Kimry to life in prison without parole. For the family and community, it was a solemn conclusion to a case that had haunted them for 5 years. Chad Hawley first came into the public spotlight in 2010 when he was involved in a burglary case in Houston. During his arrest, an incident occurred with responding officers that drew national attention after video footage surfaced, leading to disciplinary action for some officers and months of debate about policing in the city. Hawley himself was found guilty of burglary and placed on probation. After completing that probation, Hawley faced another burglary case in 2012, resulting in a lengthy probation agreement. His lawsuit against the city over the 2010 arrest incident was later dismissed by a federal judge, and for a time, his name faded from the headlines. That changed in September 2016. On the evening of September 21st, a man named David Trejo Gonzalez lost his life in North Houston during what authorities described as an attempted robbery. Witnesses reported seeing 2 people fleeing the scene in a vehicle. In October 2016, while already in custody on unrelated charges, Chad Hawley was linked to the case. In December, prosecutors charged him with capital murder based largely on the testimony of one witness. Supporters, including community activists, pointed out that Hawley had been wearing a court-ordered ankle monitor at the time, which might confirm his whereabouts. The case went before a grand jury in early 2017.
He had an ankle monitor on because of probation requirements. And so all they got to do is check the ankle monitor. The GPS location will determine whether he was there or not.
He was given multiple chances to get with the program. What was Chad Holly doing out there on the streets?
After reviewing the evidence, which lacked physical proof, like forensic links or a confirmed weapon, the jury concluded there wasn't enough to move forward. In March 2017, they declined to indict Holly on the capital murder charge. Authorities stated that if new credible evidence ever surfaced, the case could be reopened. But for now, Chad Holly was cleared of the capital murder allegations. Deputies in Pasco County, Florida, were called to a home in Hudson after reports of trouble between Adam Matos and his ex-girlfriend, Megan Brown. At the time, Megan lived there with her parents, Greg and Margaret Brown, and her new boyfriend, Nicholas Leonard. Days later, authorities made a tragic discovery. All 4 adults had lost their lives, and Adam Matos became the prime suspect. After a brief search, police found him at a hotel with his son, who was safe. Matos was charged with 4 counts of first-degree murder, and the case moved slowly toward trial. Jury selection began in November 2017, and prosecutors described jealousy and anger as possible motives. The defense chose not to give an opening statement at the start. When it was his turn to testify, Matos claimed the events were not planned. He said a confrontation spiraled out of control, and that he acted out of fear rather than intent. After hearing from witnesses, reviewing evidence, and listening to both sides, the jury deliberated for about 3 hours. In mid-November 2017, they returned guilty verdicts on all 4 counts of first-degree murder. Because the death penalty was possible, the trial moved into a sentencing phase.
One person on that jury felt enough sympathy, mercy for you that they decided that you did not deserve the death penalty. So for that, I don't have to make that decision. It's not something that I ever wanted to do or wished to do. But if there was ever a case that I've ever heard that 12 people would have decided that death was appropriate, this is probably it. But that's their decision. I believe wholeheartedly in the judicial system, and I believe that those 12 people made up their mind, and that sentence will be imposed on you. But I also agree with the victims in this case. This was the most selfish, self-centered, evil thing that I've ever heard. That you took the stand and you said that you did all of this for your son is ridiculous. Your son was in the house when this occurred. He was either in the room or within 65, 70 feet of when you shot his mother, shot his grandfather, and then waited 5 hours, by your own admission, to walk downstairs and beat his grandmother to death. In those 5 hours, you must have sat in that house with your son. He was there. It's 6 o'clock in the evening. He's not asleep. He's not locked in his room. You're sitting there with your son, with his dead mother, his dead grandfather, and a man who gave his life for those people. You sat there with him and went downstairs and off his grandmother. And you did that for your own selfish reasons. Maybe it was your age. Maybe it was that you felt that they had done something to you that you needed to get revenge for. But there was no remorse. Just saying you're sorry doesn't make it so. You're not sorry for what you did yet. Maybe someday you will be. You weren't sorry that day. You weren't sorry when you took the stand, and you're not sorry now. Your son will grow up without a mother, and without grandparents, and without a father, just as you did. But worse than you, he will grow up without a father because he will know that his father murdered his mother and murdered his grandparents. There's no worse life than that. Hopefully, with the love that he has from the Piles and the Browns and all the other family relatives that he has, he will learn to understand and be happy and learn the things about his mother that he did not know because you took her at such a young age of his. There's nothing worse than losing a parent at a young age, but to have them taken from you by your father, I can't imagine. So hopefully, some way, somehow, through the love of the family that he has here, he will grow up to be a healthy, happy, productive, hardworking, loving person. But that's not because of you. So to say that Tristan is your whole world, I don't believe that. I don't believe Tristan was your whole world. I believe that you did this because you were selfish. And based on the decision of the jury, I sentenced you in count 1 and count 4 to life in prison without the possibility of parole. In counts 2 and 3, I sentenced you to life without the possibility of parole. However, that's with a firearm, discharge, include charging death, which means hopefully that no matter what happens with the legislature, no matter what we decide on life or death in your case, you will never, ever be released from prison.
10 of the 12 jurors supported a death sentence for 3 of the victims, but Florida law required a unanimous vote. With 1 juror opposed, the judge instead sentenced Matos to life in prison without parole, bringing the case to a close. In June 2024, a custody exchange in Laredo, Texas, turned into a life-changing event for Erica Torres. She went to pick up her daughter from her ex-husband, Billy Delgado, after he called her over. As she arrived, Delgado confronted her, leaving her with severe injuries before fleeing the scene. Erica was rushed to the hospital, where doctors said her condition was critical. Over the next several months, she underwent multiple surgeries. She spent almost a year recovering and will face lasting health challenges for the rest of her life. Delgado was arrested soon after the incident. While awaiting trial, he was briefly released on bond, but later taken back into custody after failing to appear for a court hearing. His trial began in July 2025. Over 3 days, jurors saw surveillance footage, heard from medical experts, and listened to testimony from Erica herself, who described the terrifying moments and her long road to recovery. Delgado also testified, claiming he never intended to harm her. Prosecutors argued the act was deliberate, pointing to his own admissions, video evidence, and prior threats he had made.
And how on June 1st of 2024, that man sitting right there made a fateful choice that has consequences for which he must be held accountable for. Now, what choice did he make? He chose to commit the offense of aggravated assault of a family member with a deadly weapon which resulted in serious bodily injury. Let's go over those elements. You heard testimony when it comes to on or about June 1st, 2024, from the investigators that responded to the case, from Investigator Lopez to Amasquita, Mark Vela, Florencio Barrera, how they got a call and they were dispatched to 2420 North Smith Avenue for a shooting call. You heard the victim, Erica. She took the stand and she told you, she testified that she went to Billy Delgado's residence because he called her over because of some issue with her daughter. Let's move on to the second element. In Webb County, Texas. It happened on 2420 North Smith Avenue. I asked Officer Amasquita, and even Erica testified, that that residence is located in Laredo, Texas, which is in Webb County. Let's move on to the next element. The defendant, Billy Delgado. What evidence do we have? Well, we saw Officer Amasquita testify. We saw his body cam. You'll be able to take that with you in the back. He confessed. Yeah, I shot her mom, Musrar, Emmy, his daughter, who happens to be Erica's daughter as well. We see Juan Angel Pina surveillance footage, and we see it point blank. Look, it's right there, point blank, aiming the gun right at Erica through the passenger side window. Erica IDs. I heard 3 shots through my windshield, and as I drive by, I see Billy pointing a gun at me. And let's not forget the forensic scientists that came over and confirmed that there was residue on Billy Delgado after Mark Vela got samples from his hands and sent it out for testing. But ladies and gentlemen, the most important one, he confessed on June 1st, 2024. He confessed back then, and he took the stand, and he confessed on the stand as well. Check, check, check. All right, let's talk about the next element. Intentionally, knowingly, and or reckless. Well, it started May 19th, prior to June 1st. Erica and Kayla took the stand, and what did they say? Erica said on May 19th, almost 2 weeks prior to the date in question, Billy told her, enjoy your birthday, because this will be her last one. Kayla overheard that same conversation and could confirm that's what Billy said. So he had a plan already. He had a plan that he wanted to execute. And execute he did. There he is. Look at State's Exhibit 4. He's laying in wait. Erica's up there. You see her coming in a green Kia Soul. He's laying in wait, waiting to ambush her to execute that plan. And execute he did. What did Florencio Barrera say? In my experience, he was about 5 feet away from her. He didn't fire one to eliminate a threat like he's going to later claim. He fired 10 rounds. He had a purpose. A man with a purpose, walking with a purpose. State's Exhibit 5 will show the other angle of Bina's home surveillance footage. And what is he doing? She pulls over in distraught. He's walking with a purpose, fidgeting with his pockets. Go, look at it. He's fidgeting with his pockets, touching his. He goes back to his apartment and he puts his. Oh, and what else did he put up there? 2 loaded magazines. He didn't get to finish the purpose he set out for. He gets arrested once Amasquita gets there, and what does he say? I emptied a whole clip in her mother. Again, who's her? Emmy. Mother being Erica. He was in handcuffs in the patrol unit, talking to a neighbor, and you can see it on Amasquita's body cam. And what does he tell this neighbor? What am I supposed to do? I'll just deal with the consequences. He took the witness stand as well, and he admitted, yesterday, he took the witness stand and he admitted to shooting her intentionally. Now let me talk about serious bodily injury. Now, you're going to get the law from the court, which you already did. It's right here. The definition of serious bodily injury is here. Let me discuss it real quick. Serious bodily injury is bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. What did Dr. Mederos come? He came here on his busy schedule and he took the stand. And what did he say? He said that if I did not intervene and do the medical treatment and surgery on Erica, she would have 100% had a chance of dying. That at any time that he was doing his surgery, his laparotomies as he called it, which he did twice, by the way, to save her, that at any moment she could have died. I asked him on page 17 of the medical records, and you'll have him in evidence, what does hemorrhagic shock mean? He defined it for us. And I asked him, if that were to be left untreated, what could it result in? He said that her pH levels are below a certain level, to the point that if somebody has them and if they're not treated, they die. That's what she had. pH levels below the level he described to where she could have died. Ladies and gentlemen.
The defense claimed he acted out of concern for his daughter's safety, but jurors were unconvinced. After a short deliberation, the jury found Billy Delgado guilty of aggravated assault with a deadly weapon. In the sentencing phase, prosecutors highlighted Erica's ongoing medical struggles, while Erica delivered an emotional statement describing the permanent impact on her life.
We assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 50 years. No fine assessed.
In late July 2025, the court sentenced Delgado to 50 years in prison, closing a case that began with a single decision and ended with lifelong consequences for everyone involved. In the summer of 2017, concern grew among friends of 62-year-old Lisa Stuckey in Ammon when they had not heard from her for some time. Deputies conducted a welfare check at her home and made a troubling discovery. Authorities soon began investigating, and evidence gradually led them to 20-year-old Jamian K. Hernandez. Detectives pieced together information from witnesses, forensic findings, and Hernandez himself, learning that he had entered Lisa's home in mid-June. Over time, investigators uncovered details suggesting the act was planned and connected to personal grievances he held against her. On July 19th, Hernandez was arrested and taken into custody. The next day, he appeared in court for the first time.
So let's begin the business of your hearing. Have you received a copy of the criminal complaint?
Yes, sir.
Have you had time to read it over?
Yes, Your Honor.
Do you understand what you have been charged with?
Yes, Your Honor.
The charge, in case you are confused or have any questions, is murder in the first degree. And unless you tell me otherwise, I will read it specifically with you. But if you think you understand it and would waive or give up the right to reading, then we won't read it.
I'm terribly sorry, Your Honor. Would you repeat that last little bit?
Would you like me to specifically read the complaint to you?
No, sir. No, Your Honor.
You feel you understand it sufficiently?
Yes, Your Honor.
Did you see a video pertaining to rights and laws before you were brought into this hearing this afternoon?
Yes, Your Honor.
Because of the nature of the charge and the possibility of a death penalty, no bond is allowed at this time. I know it. It's not mandated that a bond be issued in a case like this, but it's discretionary, so at this time no bond is allowed. The next order of business, Mr. Hernandez, is to inform you that your case will be set for what is called a preliminary hearing.
Yes, Your Honor.
Because you are in custody, that must be heard within 14 days. The purpose of that hearing is to find out whether or not the state of Idaho can prove that you probably committed the offense alleged in the complaint. If they succeed in doing that, your case is then transferred to district court for further proceedings. If they fail to do that, it's dismissed in magistrate. You will be there with your attorney. You will have a right to question and cross-examine witnesses called against you, and you may put on a defense if you wish. That will be the preliminary hearing. We'll set that automatically at this time. Mr. Hernandez, do you have any questions about your case at this time?
No, Your Honor.
Mr. Crane, did you have any comments or business you'd like to present at this time?
Your Honor, just if we could have the court formally appoint my office, there's probably an order in the file. If we have the court do that.
There is. I have it. I was just beginning to look at it. Mr. Hernandez, I have your application for the public defender in front of me right here. Is everything on here true and correct to the best of your knowledge?
To the best of my knowledge, Your Honor.
I'll look at it at this time. Based upon the contents of your application and federal and state rules and laws, you qualify. The Public Defender's Office is appointed to represent you.
Thank you, Your Honor.
Mr. Green, thank you for being here today. Mr. Clark, are there any comments or matters of business you'd like to raise at this time?
Is the court going to announce the preliminary hearing date at this point?
Do we have a date? August 12th, or August 2nd at 1:30 before Judge Gaucher. August 2nd at 1:30 before Judge Gaucher. Now, there's one other item of business, and that is the court is issuing 2 no-contact orders pursuant to Bonneville County protocol. Each one is for 3 years. It can be modified. There will be a hearing within 14 days to address the issue of the no-contact order. And notice will be given of the exact date of that. Anything further from either counsel?
Not from either, thank you.
Noted. Mr. Hernandez, we've finished the business of your hearing this afternoon. At this time, you will return back to custody and your hearing is complete.
Yes, Your Honor.
The judge explained that he was facing a first-degree murder charge, which carried the possibility of life in prison or even the death penalty, although prosecutors said it was too early to decide whether they would pursue that option.
This morning we charged Jamie Hernandez with murder in the first degree. That carries a potential sentence of death or life in prison with a 10-year mandatory minimum, as well as a $50,000 fine. At this time, we've made no decision regarding the death penalty. It's simply too early on in the case to do that. We'll review the facts and the information over the coming weeks in order to make that determination. At this time, his preliminary hearing is scheduled for August 2nd at 1:30. I would anticipate that hearing not proceeding on that day, just based upon the nature of the case, but that at this point, that'll be his next hearing. Judge issued a no-contact order that would be in favor of some of the witnesses on the case to prohibit him from having any contact with them.
And there were 2 no-contact orders, is that
correct?
Okay. And there's no bond as well?
No bond. That's based upon the charge. The defendant's not entitled to bond for a potential death penalty case. For example, if we were to choose not to file a death penalty, then he would be entitled to bond at that point, and that issue will be dealt with then. At this point, I appreciate the public's patience with regard to the identification of the deceased. I'm fairly confident at this point we can identify her as Lisa Stuckey, but given the condition of the body and the DNA testing that needs to take place, that confirmation will take some time. That being said, there were some indications on the body regarding medical procedures and things of that nature that helped us identify the body sufficiently for this at this point.
Because of the seriousness of the charge, no bond was allowed. A preliminary hearing was scheduled, and a no-contact order was issued to protect witnesses connected to the case. In the following weeks, investigators presented evidence during a probable cause hearing, including testimony from detectives and supporting statements from people who knew Hernandez. As the case moved toward trial, he initially pleaded not guilty, but later reached a plea agreement with prosecutors. In April 2018, Hernandez admitted to the charge in exchange for the death penalty being taken off the table. Finally, in July 2018, the judge sentenced him to life in prison with a minimum of 25 years before he could be considered for release. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.